Hi, I'm Neil Garfield, editor of the Living Lies blog at www.livinglies.wordpress.com. This piece is devoted to the topic of evidence. Many of you know by now that there have been several rulings by many judges across the country who have thrown out foreclosure actions, thrown out servicers, thrown out MERS, leaving the homeowner sometimes with a free and clear house, or at least in a better position to negotiate a much better mortgage than the one that they had. The reason that these things happened is not magic, and it's not ideology. There's a difference between ideology and law. Ideologically, I might agree with the proposition that most or all of the people who got suckered into the mortgage meltdown loans of the last decade should get their houses for free for their trouble. But that's a political argument. And the purpose of this piece is to inform you about the differences between ideology and law and between information and evidence. There's also a gray area that I need to tell you about, and you need to be very careful about. Whether you're a lawyer watching this or a pro se litigant, you will all see the attorney for, we'll call it the other side, the lender, the pretender lender, the servicer, or whoever it is that's trying to foreclose on you. The attorney will come in and say, "Good afternoon, Your Honor. My name is Joe Smith, and I represent," and then fill in the blank. Might be Wells Fargo, Deutsche Bank, or whatever. You can challenge that. There's a good possibility that he doesn't know who he represents. There's a good possibility that the file was dumped on his desk and he was told to go to court. Or she. In many cases, the attorneys going into the preliminary hearings are poorly prepared and do not have a chain of documents that even shows that they were retained. The second thing that is true is that he will say, "My name is Joe Smith and I represent Wells Fargo," and Wells Fargo is the, and he might say servicer or the holder of the note, or he might use some other term. Here's the point. His representation to the court is not evidence, but it will be taken as true, which is the equivalent of evidence, if you don't object. So for those of you who have attended my seminars and for those of you who have been on the blog, you'll note that I say object to everything, assume nothing, make them prove everything that they say. The reason for that is that the party that's initiating any kind of collection or foreclosure proceeding against you is not the creditor. A creditor is somebody who has advanced money or goods or services in the expectation of receiving payment. 999 times out of 1,000, the party that you'll meet in court won't fit that description. It doesn't take rocket science to understand that if you want to make a claim on an amount due, that you have to be the one that the amount is due to. And you ought to be able to give an accounting for why that amount is due. So, in the case of a lender, the lender needs to be able to show that they advanced a certain amount of money, and here's the amounts that you paid, here's any other amounts that they received or credits or debits that apply, and this is the net that's due. That's all you're asking for. And you need to focus on that issue in discovery and with an eye towards going towards an evidentiary hearing. Now, what is evidence? A lot of people think they go into court and they say something like, Deutsche Bank is a crooked operation and I've got the proof right here, and they present hundreds of cases that have been filed by the attorney generals of states and by lawyers and by pro se litigants showing fraud by Deutsche Bank or Wells Fargo or HSBC. That would be evidence if the judge were to admit it as evidence. So what's the test of what evidence consists of? Evidence consists of what the judge admits as evidence. So you have to offer it as evidence, and the judge has to accept it, and he will only accept it if there is no objection by the other side. That's why I tell you to keep objecting if you have any doubt at all as to whether or not they're telling the truth, or if you think that they don't even know. So you offer this evidence that Deutsche Bank or HSBC or Wells Fargo or Ocwen or whoever it might be are fraudsters, and you can show all the times they've been accused of that. You know what you've just proven? You've proven a pattern of conduct, but you haven't proven, and you haven't even offered any proof that there was any fraud in your case. So what you need to do in order to make any of that information relevant is you need to show that there was fraud in your case. Now, how do you do that? Well, if you're talking fraud, sometimes it's easy from the forensic audit or truth in lending audit that you get, or forensic review or analysis. It may be apparent that there were fabricated documents, misdated documents, or breaks in the chain of title and things like that. These are documents that you can present to the judge and say, look, here's a fact. They gave me this document, and it is clear on its face that there's something wrong here. It was notarized in one state, signed in another, and prepared in another state. That's a very common thing. Evidence, real evidence that's persuasive to the judge, is evidence of facts, not opinions. Now, there is opinion evidence that you get from expert witnesses, and they're allowed to go a little bit further than what I just described, but I like you to concentrate on what is evidence, because where most pro se litigants, and to be honest with you, most litigators go astray, is they get into the whole area of trying to prove their entire case at a single hearing, and they get off on tangents. And the judge is not interested in your tangents. The judge is not particularly interested in whether you think the other side are bums. The judge is interested in what have you got, or what are you challenging on the other side.